we have been mentioned in the GDPR, and we have been dealt certain tasks in the GDPR. And based on that premise, or that thought, we asked some of the attendants, who were all privacy professionals, what they thought about the idea. And maybe not surprisingly, we received immediate positive reactions. And these positive reactions were first and foremost based on the fact that at that point, the privacy professionals and the development, even in Europe, was dealt with by American initiatives. And during the several meetings we had we learned that we had a different look at what a DPO, what a privacy professional should be, which is reflected in our European law. And based on that, we decided that we were going to start. It took a year to prepare everything, and the rest is more or less history. And we are now in our second period of 2 years, because the chair stays for 2 years. And I handed over my responsibilities with the utmost confidence to Maria, who is, I think, going to be a very capable and fantastic chairman, and will take the EADPP to the next level. And I think that is the European level, from organization that's more or less centered within, or is looking inside. I think she's going to take it to the outside world and present ourselves more than I did. So I think that's it. And I wish you very much, a lot of success in achieving that goal.
Thank you very much. And it is the first time I hear about the story about how the whole idea was generated. And it is indeed a very interested one. And I feel eager to build on the foundation laid down by you and Romeo. And I believe that the next 2 years are crucial for the association and its future. And I'm very ambitious to put all the work together with the rest of the board members to see it grow, and most importantly, establishing external relations. This is where our focus will be, with all European institutions that are active on the data protection field, such as the European Data Protection Board, the European Data Protection Supervisor, the Commission, and all EU representative bodies. And yes, what sets us apart is that, in my knowledge, we're the only European organization at the moment that represents the European data protection professionals across the EU jurisdiction. And we do want to serve the EADPP members and the data protection professionals, give them a voice where it matters. And we do take much pride in the EADPP's certification scheme for the data protection officers. This has been designed and will be open for consultation to EADPP members in early 2021, January or February. We expect that this scheme will be implemented in the middle of 2021. So if you are a data protection officer professional and wish to join the EADPP family, please go online at www.eadpp.eu to register. I don't want to waste valuable time from the speakers, even though I could say much more things about how we envision EADPP to develop. So I would just like to thank you all. Thank you, Olga, the Greek branch, all the people that were responsible for organizing this event. And last but not least, the speakers for a very insightful and informative webinar. Thank you very much.
Thank you very much, all of you, that you really stay at your time. I would really like to hear more and more about this association, which I adore. You know, Mark and Maria, how I adore. So, Dimos, the floor is yours to do all the necessary. Thank you very much. Enjoy the event.
Hello again. Good evening to all. Thank you, Ms. Tsiptse, President of EADPP, Ms. Maria Rafael, Mr. Mark Brehoff, Chairman of the Greek branch of EADPP, Ms. Olga Tsiptse, dear speakers, dear attendees. I would also like to welcome you in the second online seminar organized by the Greek branch, which we hope that you will find interesting as it covers issues that you all face at the current period. As the General Secretary of the local branch and the moderator of this webinar, at this point I would like to present the two speakers of the event. The first speaker, Ms. Harazerva, will bring to discussion issues concerning teleworking and tracking contacts in COVID-19 era, on whether Europe was ready for processing of data compatible with GDPR, legal issues and concerns over the use of platforms through which data is transferred to third countries, etc. Ms. Zerva is a Supreme Court lawyer and an accredited mediator. She was admitted in Athens Bar Association in 2000 and is managing partner of the law firm Nicholas Kanelopoulos and Harazerva and Associates. Ms. Zerva is accredited mediator since February 2014, member of the board of International Jurists Legal Network since 2006, member of the board of directors of the Greek Law Firms Association since June 2011, and finally, she's a GDPR expert and a DPO consultant. The second speaker, Mr. Ioannis Kalias, will bring to discussion issues concerning teleworking, tracking contracts, technical issues and technical security measures, concerns and challenges, whether companies are ready in Greece for teleworking and technical issues, and finally, concerns over the use of platforms to which data is transferred to third countries, SREMS2, etc. Mr. Ioannis Kalias is a production mechanical engineer and holds a Master's Science in Quality Management. He started his career as a junior manager in quality assurance and joined TÜV Austria LS in June of 2000 as an auditor of quality management systems. In 2010, he was taking over the position of the general manager of TÜV Austria. Under his management, the Greek legal entity tripled its size, spreading its activities in many sectors, and established several daughter companies abroad in Cyprus, Albania, and Jordan. Starting from 2015, for 4 years, he served as second general manager in TÜV Austria, served in Vienna, Austria. And since March 2020, he is the business executive director in the business assurance business area, which comprises the business streams of certification, training, and legal compliance worldwide. Nowadays, 11 general managers of TÜV Austria Group affiliates in several countries in Europe, Asia, and North Africa are reporting directly to him, while he's the group top-level management in certification, training, and legal compliance services as well. He actively participates in the executive committee of the TÜV Austria Group as the first non-Austrian in the history of the group. Ms. Zerva, Mr. Kalias, the floor is yours. And to all attendees, please note that all questions will be answered at the end of the presentations. Be so kind and write down any questions in the chat box. I thank you all and have a good time. Ms. Zerva, the floor is yours.
Yes, thank you very much. I would like to thank the panel as well as the attendees for the kind invitation. As you all know, I'm replacing Nicholas Kanelopoulos, who is a managing partner of our law firm as well. I would be happy to share with you our experience as a law firm really deep down in the privacy field. Actually, I have a team with more than 10 legal experts comprising with the matter, and we serve many private and public entities as DPOs and consultants on the matter. So I think that our experience, at least in the last year, is something that I'll be happy to share with you. In the meanwhile, I will try to share the screen, I hope successfully. So give me a second in order to start the presentation, which is here. So give me a second. I think I'm done, but I'll start through the beginning, the first page. Is it okay? I think it's all shared. So as you already described, the issue to be dealt today will be the personal data issues that emerged the last year. And going back to the, to the 2020, in a glance, we can say that we faced the year of the pandemic, which was circumstances extraordinary that gave rise to new global circumstances and the reevaluation of vital priorities. This was the case. Under this case, new legislative measures, all in national, European, and global level, were undertaken. And a branch of new technology set was set in place as a response, an effort to respond to the pandemic. At the same time, on a judicial level, I think the hot issue was the Schrems II decision that put under scrutiny the international data transfer, which is an issue that is going to be of great importance in the next months to come. So if we could sum up through the words of Mr. Vivorovsky, the European Data Protection Supervisor, would say that the outbreak of the COVID-19 is affecting our lives at an unprecedented pace. It is testing the resilience of our societies as we respond to this global crisis and try to contain its consequences, both in the short and in the long run. So the question that is really set and is really taking a lot of effort through the practitioners of law nowadays was whether Europe, and actually the European legislation, was actually ready to face the pandemic from a data privacy point of view. The circumstances were extraordinary. The processing activities that were obliged to undertake were exceptional, and the goals and purposes set in order to prevent and to safeguard the global health, and to prevent the crisis were really of great importance. So the European legislator is found to be really wise, since a couple of years ago, actually not a couple of years, many years ago, was really precautious in order to provide all the appropriate legal basis and the general principles for us today, so as to be able to execute all the processing activities on these extraordinary circumstances. The legal basis, of course, are set on the Articles 6 and 9 of the GDPR and the recitals 46 and 52. And they permit actually the collection and processing of personal data for reasons of public interest in the area of public health, and of course for humanitarian purposes, for monitoring epidemics and the prevention of their spread. However, all these processing activities should always be taken after having undertaken all the adequate safeguards for the protection of the rights and the freedoms of the individuals. At the same time, what was really important to take into account is that all this radical development of the new technologies led to the necessity to undertake robust policies and procedures to make sure that we have data privacy policies in place, business continuity plans, data recovery policies, data breach policies, and of course that all the major entities, legal entities, have undertaken the technical and organizational measures set out in the GDPR, encryption, anonymization, access codes and passwords, in order to approach this situation. The fast adoption and the compliance of the stakeholders with the situation, the awareness, the staff training, the reporting lines was an absolute necessity, and all the practitioners of the privacy field were really set in a position to be able to instruct their clients to put in place as soon as possible. The measures along that were taken in this COVID era had always to take into consideration the necessary proportionality issue and the necessity issue, the requirement. They had always to keep the balance between the public interest and the maintenance of the public and private health on the one hand, and the individual rights and the freedoms on the other side. We had always to keep the balance. However, what was the outcome of this exercise is that, of course, the right to the personal data is not absolute. We can always put in place the necessary procedures, having taken all the necessary measures. Moving forward and getting in the field of telework and remote work, this is a need that we can say that it was something we had never thought of before. Nobody had considered that we would be obliged to stay at home and set ourselves in front of a screen and learn how to work under these circumstances. Of course, on a legal perspective, this confused the situation since the professional and the private space were merged. This increased the intrusion on the private sphere of the employees and blurred the boundaries between the professional and the private life. At the same time, the Hellenic Data Protection Authority was really quick on that issue. We can say that since last March, really in the kickoff of the pandemic in Greece, with the resolution number 5, set out the guidelines under which had to be taken into consideration in order for the telework. So the guidelines set out that the GDPR and the Greek principles set in law, the relevant national law, should always be met. Of course, we should always take into account that the employees expect a greater sphere of privacy when they stay at home, that is, when they work at home. So the necessary proportionality and necessity testing should always take place before putting the telework and the certain prerequisites in place. So the technical measures should be ensured, the security and confidentiality of communication and work should be taken into account. And in this direction, the DPO's data protection officer's role for the entities that put this procedure in place is always absolutely necessary in order to make the parties aware of their obligations and their rights, and of course, in the assessment and the mitigation of the risks that have to be undertaken. Further, looking on the future, what is expected to be to come up in the European and the national level regarding the telework is the right to disconnect. And actually, this is a resolution of the European Parliament that is expected to be voted in January 2021 through a directive that is going to establish the right to disconnect. What is the right to disconnect? Actually, it relates to the ability of all workers, all people, to disconnect from work, primarily not to engage in work-related electronic communications, such as the emails and the messages, when they are in non-working hours. This is going to be an evolution. I don't know if it could be actually set in place, but we're expecting to see how this will work. And at the same time, on a national level, we have the public consultation since the beginning of this December of the digital transformation paper for 2020-2025, where teleworking is set as a strategic goal towards the digitalization of the public sector in our country, in Greece. Another topic that was really important, and I think that it took a lot of legal discussions, was the contact tracing applications. This is the new technologies that we discussed earlier. We refer to the applications that are developed in order to trace the contacts of COVID and the COVID relations. The initiatives were taken both on a national and European level, and the processing of personal data is being taken into consideration since all these smartphone applications are going to record and process our personal data. However, even in this case, there is always the fundamental question of whether the processing is necessary, whether this is suitable and appropriate for the purpose in place, and whether the principle of privacy by design by default is taken into consideration. The outcome of the legal discussion under this field and the directions already issued is that the implementation of the data protection framework should not impede the adoption of all the necessary measures, and of course such applications can be deployed as long as they are technical correct. At the same point, on another field, on the judicial field, the important issue of the year that is coming to an end is the decision on Schrems 2. Actually, this was a proceeding, as we all know, that was brought in Ireland by Max Schrems against the Irish Data Protection Commissioner relating to the Facebook data transfers to the US. The question set in place was whether the GDPR is applicable on data transfers in situations where a third country is processing data for public security and law enforcement purposes, whether the level, what was the level of protection under the standard contractual terms of the GDPR, Article 46, and whether the privacy shield that is between the European Union and the United States ensures the adequate level of protection that the Article 45 of the GDPR requires. Actually, the outcome of this decision is that the privacy shield is not valid related to data transfers to the US. And of course, this data transfer should be reevaluated and reassessed on a case-by-case assessment. The standard contractual terms already in place are still valid, but the consultation is going to bring out the outcome for the adoption of the new ones. But until then, we consider them as valid. And the outcome of this situation is that the Schrems judgment put an extra burden for the exporters of personal data, who should perform the exercise of proportionality and assessment again and again. In each case, take extra measures, supplementary measures on transfers to countries that are not considered to have the adequate protection level, in order not to upfront the high fines, since there is no grace period for the compliance that needs to be provided. Finally, in order not to take more of your time, we think that the data privacy environment is constantly changing, along with the situations, the extraordinary that we're facing. Yet the basis on the GDPR, I think, are really solid and give the margin. This is, at the end of the day, I think it's a wise legal document. It is vague enough and broad enough so as to leave the margin for the legal interpretation that is absolutely necessary for the controllers and the processors, and in order to leave the space for the processing activities that are necessary to safeguard the human life and the human health, which above all, I think, is the most crucial of everything. The DPO's role in all this situation, the legal expert, the experts actually, is really crucial, and their guidance is tested to be the most necessary help in this procedure for the companies to take the necessary measures and to upfront the new situations. That is all of us. Thank you very much. I think. we're done. I don't know if, okay.
Thank you very much.
Thank you very much. Okay, I was really lost with the tabs here, the buttons.
Don't worry, you can stop sharing. I think it's in the
Yes.
bottom.
Okay. Okay. That was what I was trying to do.
Thank you very much for all this informative, Dimos.
Okay, yes. Thank you, Ms. Serva. Ms. Ioannis Kallias now will give us the more technical perspective of the issue. Mr. Kallias, the floor is yours.
Yes, good afternoon also from my side. I feel actually quite blessed that I'm together with you in this very nice event, and thanks a lot for the invitation. However, when actually Ms. Olga Tsiptse invited me in written in order to participate, actually I was wondering what I have to say among so many GDPR professionals, and as long as I do not belong actually to GDPR professional with, let's say, the close view of the definition, I was really wondering. However, I didn't raise this question, so I didn't get any reply. But let me actually share with you how I can see in a few words the role of a GDPR professional, as long as we're discussing now within the EADPP community. I will transfer to you actually a practical example of how we treat pandemic here in Greece regarding T4 operations here in Greece, but from a business point of view, not from a close view of GDPR requirements. So I'm going to share with you topics regarding corporate governance, some information security topics, and of course, including business continuity and data protection topics, but not in a big length regarding the way that I'm going to approach these. To my belief, I see the GDPR professional role not only a person who is dealing in a company or consulting or advising companies regarding the GDPR requirements, but also a person who has a broad view of entrepreneur topics, a broader view of legal requirements, knowledge, and of course at the same time he or she to be able actually to communicate with the top management within a company in order to set up the real frame of a company's operation. And this is how actually we are trying to do it in our company in Greece, in T4 in Greece, and this is actually what I'm going to share with you. Yeah. Okay. As we are actually in the second wave of pandemic, not only in Europe but also worldwide, we now have many more positive cases and unfortunately fatalities compared to the first wave. However, we all can see that people do not obey in the way that they did it in the first phase of pandemic, and at the same time actually they feel tired, as all of us. They feel that actually their personal freedom has been somehow restricted for this from this pandemic, and at the same time there are sectors were actually crushed during pandemic, as the tourism industry, restaurants in general, catering business, and of course whatever connected with traveling, it is also crushed. What we expect based on the European Union information, we're expecting more or less a two-digit recession during 2020, and this is something that we should take actually into serious consideration when we also discuss regarding the personal data requirements and their protection. Actually, it is worth to say that the human losses that we already have, it can be compared with a war so far. I don't know if you have already seen the figure in US, where actually, unfortunately, in US, more than 300,000 people already dead, where actually in the Second World War, the fatalities were, I think, 250,000. Actually, this gives also somehow a more clear picture of where we are. In order to cope with the pandemic, we need, of course, a business continuity plan, and business continuity actually entering in our lives in a more, let's say, in a more offensive way, in order to make us all more ready in order to cope with all these challenges. The main considerations actually to implement a holistic business continuity plan, which has to be the base to cope with pandemic, is to determine the impact, of course, in companies' activities, to see all the health and safety issues in companies' personnel, also to cope with all the other HR issues, including personal data protection issues. But in order to be able to further continue as business, you need, of course, a very well organized IT system which actually can cope successfully with all the security issues, starting from phishing and ending actually in more sophisticated ways of penetrating in your systems, in order to be able actually to further continue your business. Of course, supply chain issues and internal and external communications, as all the marketing topics, are very, very important in order to assure business continuity. From a government's point of view, from the governance framework, actually, what we did in the company starting from early March, where actually the first lockdown was imposed not only in Greece, but more or less in most of the European countries, were actually to organize successfully a team, a crisis management team, where top management, HR director, head of companies branches in the country. We have 4 branches, actually 4 offices around the country. The heads of the company's main departments and the key company's administration personnel, which who were actually accounting, credit policy, marketing, and of course DPO, were invited actually in everyday meetings in order to see how we're going to cope and to see actually the trends of the market, and at the same time to cope with the challenges that we had to face from the one day to another, in order to have teleworking almost for all the persons, at the same time trying to find out ways in order to assure business continuity with all the problems also deriving from GDPR requirements, not problems, challenges, I would say. And at the same time, of course, we had to have full compliance with the official governmental legislations and regulations, and where absent, we were in a more preventive, actually, mood by delivering specific instructions, actually, to our persons and within our society. We employ in Greece around 150 full-time employees, divided in the 4 offices, as I said before. So this was actually the first reaction when we faced this pandemic. From the information point of view, we initiated a new information security policy, which was communicated to all the staff and includes instructions for physical security measures, internet, remote connections, portable media security, and data privacy topics, and not only communicated in written, but we organized in small teams a communication with all our people who were sitting mostly at home at the time, in order to be able that, in order to assure that they were able to understand what actually we're asking from them, as long as we open, of course, file servers from home, and we gave full access actually to all the servers and web platforms we're using during our daily work. So we had to secure through VPN access and through several other measures that we're doing things in the correct way and in the safe way, safeguarding the assets of the company, and of course avoiding any let's say bigger risks. At the same time, we monitored together with the central IT in Vienna 24/7 our IT infrastructure, and in order to, let's say, avoid unnecessary risks, and we provided 6 days per week continuous online support to all our personnel in our actually entity in Greece, and of course worldwide. I'm talking now for Greece. Regarding the personnel data privacy, we prohibited the visits of external partners right away from the first stage of pandemic, customer suppliers, and we didn't accept anymore any visits to our company's offices. With this measure, actually was avoided somehow the extra health checks regarding temperature checks, COVID checks, etc. However, at the same time, we didn't collect information and data derived from such a kind of checks, but only recorded data of our own personnel, and these data are kept only for the period that pandemic will be with us, will be in place, unfortunately for all of us. We don't register any other information for the very limited number of people who actually visited our office during the last 10 months, I would say, 9 months to be more accurate. We strengthened at the same time, in collaboration with the IT department, the monitoring and implementation of technical and other organizational security measures. And of course, we fulfilled the HDPA, the Hellenic Data Protection Authority, guidelines regarding COVID-19. And we heard actually from Ms. Zerva in her presentation that it was actually quite nice that HDPA reacted on time regarding this pandemic. But life is going on, and we didn't get only measures regarding information security, governance, data protection, but also we initiated the quite well-known COVID Shield, which is actually the most based on some European data that we have in our hands, the most successful private certification scheme in Europe, where actually for the time being has been adopted as a management system which provides confidence to employees and clients that mitigate the infection from the infection risk from COVID. if it actually applies. So we have already more than 250 big retailers certified with this COVID shield, including also many hotels from the hotel industry. So we have in Greece and in other 7 countries more than 3,500 points already certified. And at the same time, regarding the personnel certification exams, we conducted actually through a sophisticated teleproctoring software system more than 2,000 professional exams during that time, and including many exams of data protection officers who have attended, of course, remotely these exams without any incident concerning privacy and data protection. And I have to say, by finishing my word now, that when actually we discussed regarding the data protection requirements that the platform, the teleproctoring software platform that we're using with the supplier of this platform, I have to say this actually company was located in Germany, and I have to share with you that the level of their actually awareness regarding data protection requirements was not so high. I mean, we spent more than 6 months in order to establish actually a system where all the data protection requirements have been fulfilled. So all in all, actually, this was what I have to transfer to you and to share with you. And you know, as I can define myself more as an entrepreneur, less than a GDPR professional, I have to say that when everyone is moving forward together, then success takes care of itself. And this is something that we have to have in our minds, as long as we all hope and wish that 2021 will be a quite different year, and we will set up the basis for being to get rid of actually from this pandemic, at least the second half of 2021. We all hope and wish that this will be in place. So again, we will be free, let's say, but in a new normality, in order to continue our business and personal lives in a more smooth way. Thanks a lot, and Merry Christmas and Happy New Year to everybody. Thanks a lot.
Mr. Kalias, we thank you for your thorough presentation. At this point, feel free to write down any question concerning the topics covered during the seminars. We have already some questions set by the attendees. Mr. Yannis Kalantzakis has said this question: when is expected that the certification for GDPR compliance for legal entities should be obligatory? Thank you.
May I reply?
Yes, this question is headed to all the panelists.
I don't think so, finally, that we will have a scheme where actually, a certification scheme where actually it will be an obligation for the companies in order to be certified for GDPR. But we all know that there are already guidelines coming from ISO 27001, 27701, where actually somebody actually can adapt in order to go on. But this is not a certifiable standard, as we all know. It is guidelines for being adopted by the companies that they wish to do it, which means that there are no international certifications provided. And of course, there are several private schemes regarding certification, but not actually, let's say, unequal to what we know as ISO standards for the time being. I don't know, and I don't think that we will have in the near future you know, a wide applied certification. Thank you.
I would
Yes.
like, first of all, I would like also to thank Mr. Karias about his presentation. That's why we asked him to be with us today. I would like to say to all the attendees that if they want to ask themselves the panelists, of course, we can unmute them and ask directly. So if Miss or Mr. Hannah Preus, is that right? Do you want to ask? Can you hear us?
I just, yeah.
Oh, okay.
Thank you. I just ask you, yes, if there is any particular course which you can recommend for, I think for two, because there are two different, the GDPR and data protection officer.
Sorry, can anyone?
Yes, maybe I can. Since 2018, we've seen many initiatives of organizations, new organizations on the market providing courses for privacy professionals. That is for lawyers who want to specialize in the area, but also for more generic professionals who want to provide or get a job in this area. Is there a best practice? I think as the GDPR itself is still is a framework, also implementing the GDPR, advising and controlling the process of implementing the GDPR within organizations is also a framework. And it's, I think, very early days to say, okay, this is a best practice in training in a course for becoming a DPO. So it's a difficult question to answer. And I think, but that's my personal opinion, I think implementing the GDPR has really two sides. You have to be able to understand the theory of the GDPR, so that you really have a good grip of the legal part, but also a training needs to take care of what do I need to do? And that I'm not talking about writing a privacy statement or a processing agreement. No, I'm talking about how do I help an organization to transform into a GDPR compliant organization, and
Exactly.
that's change management.
Yeah, exactly.
So
this is what
you really have to look at those two angles and judge the training that you want to that you choose and see if they bring both.
Okay, I see. But that okay, that's fine. Thank you so much.
So if you want to elaborate more, please tell us if you want to ask something more.
I understand what Mark said, that there is no any particular course which you very experienced, and thank you very much for organizing this event. You can just recommend to cover these two aspects, as I understand. It's just, yeah, from my responsibility to check and see if these two parts will be covered.
Yes, I think that's very important.
Thank you.
Okay, thank you. We have a question set by Ms. Anna Demo. How is lawful according to GDPR to check out the temperature of the workers or people entering public services, for example, lawyers entering the court?
To whom? Maybe Mrs. Zerva?
Yes, of course. Actually, according to the proportionality control check described before, it was concluded that, of course, the temperature is something that can be checked thoroughly in order to prevent the public health within the courts along with the lawyers. So this was the balance check described before. This is a control that led to the result that, of course, you can take such measures as long as you don't record them, of course, but you prevent any disbursement of the contamination to the public within the courts and the public sector. Is that enough? Is that clear?
I think it's clear. Can we read what Sofia Tsiptsea asked and Mrs. Zerva replied? Dimos, can you please?
Let me find the question, because the question, okay,
It's
yes.
answered.
Ms. Zerva, about SHREMS 2, the situation with using platforms that may transfer data to third countries is as follows. Are we waiting the issuance of standard contractual clauses to sign them? And what is the opinion of the other European authorities? Thank you.
Actually, we're still using the standard contractual terms already in place. Of course, the consultation just finished, as I explained before, so we are expecting the updated version. But in the meanwhile, we can sign the standard contractual terms already in place, and of course, add on them the additional safeguards that were described from the EADPP. To the extent that the measures with the contracting country are not sufficient, we can add these measures and feel that we're on the safe side. In the meanwhile, as long as the final text, the updated text is set into, becomes published and public, I think we should be, we will be in the position to update to the new version.
If I may add on this point, as EADPP, we have contributed to the consultation initiated by the European Commission on standard contractual clauses, and we formed a group from several local branches. And on the 10th of December, we submitted a document detailing where we have some observation and comments on several section clauses and modules of the standard contractual clauses. Just to share this information with you all.
Thank you very much. It was a great task force,
Yes.
task group.
The Greek branch has participated through Olga and Sofia and Dimos as well, who offered their comments.
And thank you very much for this opportunity and this initiative from you, Maria, as the chairwoman. Thank you very much. Thank you very much for that.
And also Tassos Malsagos.
And Tassos, I forgot Tassos. I'm sorry, Tassos. I hope that you will excuse me for my mistake.
One more question on behalf of Ms. Polixeni-Tsoni. Ms. Zerva, could you inform us at the time the updated SCC template will be provided?
Excuse me, when you want me to inform you when this will be provided, the updated text? That was, of course, I will do it with great pleasure. As long as we have it, I can send you out.
We expect to receive the revised standard contractual clauses in early 2021.
Yes, end of January, something like that. It's supposed to be. Okay, nobody knows exactly. So
nobody knows.
Before continuing to the one more question, can you please elaborate all of the panelists and maybe the attendees, if they want to contribute to that? How do you, how can you judge in, that we had in so little time a draft for these clauses, And in so little time, we had to contribute with public consultation. And of course, with so little time, it is going to be elaborated as a clause that we can use them in this data transfer to the third countries. I think that it's so limited time for this very serious and very significant task. Can you please judge this all this situation? Because it's, for me, I was wondering why we are running, especially for such a big issue.
May I? One sec.
Yes.
I think first and foremost, I think yes, the data subject is central in the protection of data protection, and the data subject are central in the GDPR. But it was originally created, or it came to life, because there is also another interest, and that's the economic interest, the transfer of data across borders that needed and that could not be hampered by the public, the data subject, losing trust in what organizations would be doing with their data. Now, if you look at SHREM 2, suddenly a huge market is being cut off with and the consequences were going to be immediate. And then suddenly under that pressure, the same with vaccine COVID-19, in just a year, our scientists have achieved something that normally would take 15 years. And I think the standard contractual clauses are a necessity in the short term to solve a large issue, and that's the hampering of data transfer across international borders. I think that could be an explanation for the speed in which this process has been managed. That's what I think.
Are we sure that while they were waiting from the SHREM's decision, they did not do a preparatory work on the standard contractual clauses? Maybe.
I wouldn't be surprised.
But I'm sure they had to speed up the process following the SHREM's decision and act fast, as with the COVID and the vaccine, that we have seen in a matter of some months due to urgency.
Yes. I have a question. And that relates to Article 6 and Article 9 as presented by Ms. Serva. What would your opinion be if the government would have ordered telecommunication companies like Vodafone and so on, based on 9 and the 52, I think, and 53 and 54, would have said this is such a dire situation. We need these data to control this pandemic, and therefore we seize the data instead of trying to build apps and use the regular telephones to obtain the information from individuals without their consent. Would 6 and 9 be sufficient grounds?
I think it would be sufficient ground for the companies of telecommunication in order to provide to the state the data. At the end of the day, however, this transfer of data and processing activity would be always subject to the constitutional control. And at the end of the day, it will be the courts the Supreme Court of Greece that would have the final word. In this exercise, I suppose that it might be out of proportion, but this is a really personal point of view, and it would relate to the exact details and the conditions under which it would be led to this situation. If they were extreme and the justification would be sufficient enough so as to explain that this would be the only means in order to preserve the situation of the public health, this would turn out to be proportionate. If not sufficiently justified, I suppose that under the Greek documentation and the constitution, it will be out of proportion.
Okay. So Article 9, the exemption of Article 9 is really only available in extreme, even more extreme than pandemic proportions.
The pandemic is an extreme proportion, but the justification for the specific measure each time and the circumstances under which you justify that you are obliged to undertake, and if this was the only means and there are no other alternative means to lead to the same resolution, to the same result, is the crucial issue every time, I think. I mean, if you have other milder means to end up to the same conclusion, you don't have to undertake. Then this is not proportionate.
Yeah.
This is, I think, the basis.
Okay, thank you.
You're very welcome.
Mr. Christos Poulios, does he want to raise a question? If he's attending the event, he can open his microphone.
Wait a minute to
Mr.
enable.
Mr.
Maybe.
Michael, okay.
And
Is
then
this
Michael.
Michael Spratt
from
wants
our-
to.
Yeah.
Yes, Olga.
Michael Spratt is the chairman of IRIS branch who has the next event on January. So I would like him to say something about what he has heard or to contribute with his brilliant idea, because IRIS DPC is a very active data protection commissioner office. So I was attending to the previous event of IRIS branch, and I was very delighted about how they are facing all this situation with data. And they have a network about DPOs who can be informed about all the things that, all the issues they face. So if Mr. Poulios doesn't want to unmute and ask his question.
No, I'm present now.
Okay, thank you very much. Can you elaborate, because we couldn't understand the question?
Yes,
about...
I would like your comment on public services. Do not respond to emails unless sent within business hours. Is it a kind of exercise of the right of disconnection or something like that? What's that? Because we have problem with this.
Shall I reply? Okay, I think that if we were under normal conditions, then the working hours would be explicit. I mean, either 9 to 5 or whatever, 7 to 3. So, okay, of course, this is a free task to the right to disconnect. They have the right not to reply all day long. This should have been the case for lawyers as well. This is not in private professionals. This is not the case, yet this would be wisable in order to retain some time of some space for privacy and private life. This is the necessary balance for our lives as well. If we can achieve or not, this is the big question.
Okay.
But this is an effort towards the right direction, I think. Not necessarily the right to disconnect, but the timeline within which at least the public sector should serve.
Okay, thank you.
Very welcome.
Thank you, Mr. Poulios. Mr. Spratt, are you here with us?
He wants to unmute him all. Yes.
You can unmute. You can unmute. Yes.
Unmuted now. Can you hear me?
Yes.
Yes.
Listen, thank you very, very much for a very, very entertaining session. I just have a comment that here in Ireland, we seem to be particularly badly affected by the confusion around standard contractual clauses and international transfers. As you know, we have an awful lot of American businesses here who want to move data across the Atlantic. And now with Brexit coming, we have a very different sort of problem. And perhaps people might have some comments on this for us. We have a lot of small businesses in Ireland who trade across the border into the Northern Ireland, which will be part of the UK that's leaving the European Union. So while on one side we have large corporations with large numbers of legal advisors who are capable of filling in things like standard contractual clauses, would you have anything to say for a small business or charity, perhaps with 50 or 100 employees who are using a payroll provider on the other side of the frontier?
Mark, would you like to reply? Or Mr. Kaliasos, Mrs. Serva, or Maria? Very difficult issue, Michael said.
Michael, what is your own answer to the question?
I would suggest to the Data Protection Commission that perhaps they should find somebody else to pursue. But, you know, there are more important things for them to follow up on. But at some point, we will have to find a workable solution to this.
So you're looking for a grace period?
I think a grace period is probably the best solution for now. But I'd be interested in hearing your opinion, Mark.
Well, one of the things that really struck me in the document recently presented by the EADPP regarding especially the way you need to examine the legal ramifications of on a national level of transferring data. And I'm not the first one who says that, but it really is something that is for SMEs, is in general, even doing business on as a small startup with an idea that brings data not all over Europe, or that has customers all over Europe, but all over the world. And having to diversify your network because of latency questions, then suddenly you have a problem. You suddenly have to invest large amounts of data, of money, to find out what it means for your organization, and that makes it for SMEs in a non-executable. You are not capable of executing upon these requirements. It's too costly, and I don't think that was the aim of the GDPR in itself. And now they turn it into such unattractive, from a business point of view, an unattractive construct. So I would say grace period, but even for SMEs not processing sensitive data, you probably have to come up with a different solution.
For the new standard contractual clauses, there is a grace period of 1 year, but still a startup or an established company must still adopt either the existing or the new standard contractual clauses. And with the Brexit, a lot of companies will need to adapt. And the thing with the standard contractual clauses that we have noticed as EADPP, and it's very costly and a big burden for organizations, is that it requests from the company to make an assessment of the local laws.
Mhm.
But this is a very big requirement and a very demanding, sophisticated, and time-consuming task to be undertaken and carried out by the organization. So what we suggested to the Commission is to proceed with, to help us by proceeding with a pure assessment of the law of third countries, on which the organization can build their own assessment in relation to the intended transfer. Because otherwise, we cannot safeguard that the organizations will have the means and the resources to identify all these laws of all these third countries, make the correct assessment of these laws, and then proceed with the assessment taking into the specific considerations of the specific transfers. So I hope that the Commission will assist the organizations in this way. Because if we need to comply with this standard contractual clause and make our very own assessment of the local laws of the third countries, I don't know how the organizations can manage to fulfill this requirement.
Is there going to be a difference between a no-deal Brexit and a deal Brexit?
No, I believe no. No, Michael, am I right? There's no difference in between deal or no deal Brexit.
Yeah, it's really down to whether there's an adequacy decision or not.
Yes. So as long as there isn't one,
Mm-hmm.
we're obliged to use the standard contractual clauses.
Maybe one question, and I don't know the answer, but I remember that in the divorce papers, the contract or the agreement that was first negotiated, that there also was talk of a grace period that or not regarding the GDPR. I don't know. It's something that
I believe not, because as of the 1st of January 2020, UK organizations that market their services or offer services in the EU, they will need to appoint an EU representative. So they will be considered as a third party.
Yeah.
In terms of GDPR.
Okay.
Zerva or Mr. Kalias, do you want to say something about our discussion?
Actually, in the same direction, if I could add that, of course, according to the GDPR, the measures and the technical measures undertaken every time should be proportionate, and to the extent that the entity, the legal entity, can afford. So when discussing about SMEs, of course, the undertaking measures and the evaluation and the assessment that should be evolved can never be the same as one of a flagship public entity or a private entity of a big volume. To this extent, I think that the solution to the matter, if not provided by the public, the EADPP or the commissioner, will be driven by the practice. I mean, there's no other way around. Of course, an SME can never address a dissertation and an assessment of the legal status and the provisions of a third country, wherever it is, and take the necessary, the proper decision. If there are not guidelines, they will never properly proceed to the necessary assessment as Mr. earlier described. I think it will be really hard.
Yes, but it will be a lot of work for the Commission to come up with assessments for each third country.
Of course.
But if it's hard for them, then it's harder for us.
I think it's impossible for the SMEs. It would be impossible.
Yes.
Impossible.
Yes.
Okay, at this point, I can see no more questions. If you have any questions, you can send them to the email address greece@eadpp.eu to be answered at a further time. I would like to thank all panelists as the moderator of the event, as well as the members of the board of the Greek branch of EADPP, Ms. Sofia Tsiptse, Mr. Tasos Malisagos, and Mr. Lefteris Chiliudakis. Together with Olga, they managed to organize this webinar, the second during the current year. Finally, I would like to invite the President of EADPP Europe, Ms. Lafael, and the Chairwoman of the Greek branch, Ms. Tsiptse, for their last remarks. Personally, I thank you all for your participation, Ms. Zerva, Mr. Kalias, Mr. Veihov, attendees, and I wish you all the best. And don't forget to stay safe.
Thank you.
Thank you very much.
It was our pleasure. Thank you.
Thank you very much. And I won't speak anything anymore because I was glad by the issues that were covered. I would give the floor to Mark Vreihov, Maria Rafael, Michael Spratt, or Dietker Koopmans if they want to say something at last. And I would really appreciate Mrs. Harazerva and Mr. Ioannis Kalias for being here with us and giving all these good things that we heard about them tonight. Thank you very much.
Our pleasure.
It was our pleasure again. Thank you.
Thank you.
All the best for all of you.
Bye-bye. Bye-bye.
Mark,
Yes.
do you want to say anything
I
to the
want.
participants?
Okay, no, okay. What I want to do is to first congratulate Olga and everybody who and Dimos for a successful second webinar and the efforts they put into EADPP. I enjoyed very much the presentations and liked the discussions. Which I always like, having discussions, and triggering our thoughts and trying to test what is possible is what these webinars should be, knowledge meetings, where we exchange knowledge among each other and among DPOs, among data protection professionals. And this is not only a discussion among DPOs only, but also inviting people who are looking at this from a different perspective is I think going to be very important, because those are the areas that we as DPOs have to cover. We have to know something about marketing, we have to know something about technology, we have to know about all these areas, and therefore I would like to end my remark by also especially thanking Mr. Kalias for his presentation, which I found interesting, but it's not my area of daily expertise to learn how you look at this from your perspective. And I think these dimensions need to be involved in these knowledge meetings. So that's my comment. Thank you.
Okay. And I wish to praise the Greek branch, Olga Tsiptse, the president of the branch, and all board members for organizing this very successful and insightful event. I really enjoyed it, and it led to a discussion between data protection professionals that I really enjoyed, and I really look forward to the next meeting of the Greek branch. I don't know when this will take place. Sorry, Olga.
Sorry, sorry for interrupting. Now we have Irish branch.
It's the Irish branch, okay. And I really wish to thank the speakers, Mrs. Zerva and Mr. Koulias. Did I mispronounce his surname?
Don't worry.
That's Kalias, I think.
Kalias.
It's A, not
Okay.
O. Don't worry.
So Michael, it's your turn. For the yeah.
All I can do is second what you've said so beautifully there, Maria. It's another great event by the Greek branch, and thank you very much. And while I'm here, I would just like to take the opportunity to advertise our own event that's coming up on the 28th of January at 12 noon Irish time, so 1300 Central European time. And I suppose that's 2 p.m. in Athens and Cyprus. It's a first chance for us in the Irish branch maybe to have a look with a legislator, a member of the Irish Upper House. She's a qualified or practicing barrister, as well as a member of our parliament. And it's digging into this topic of the mother and child homes. We had a situation here 20, 30, 40 years ago where unmarried mothers went into these special homes, and now that's being unraveled, and what should happen to that data. So it's the interface between a social problem and data protection. And that will be on, as I was saying, on the 28th, and all members will be invited. But thank you very much to the Greek branch for today.
Very inspiring, as always. Thank you very much, Michael. Ditker, are you here with us? Ditker? No. Okay, let's not bother you anymore. Mrs. Zerva Hara and Mr. Kalias Ioannis, thank you really very much about your presentations. And I hope we can talk together for the next hour of our events. Thank you very much.
You're very welcome. Thank you.
Thank you.
Thank you very much.
Very much.
We thank you all. Have a good night.
Bye-bye. Thank you.
Bye-bye. Thank you very much.
Bye.
Bye.
Bye-bye.
Okay, bye-bye, Olga.
Bye-bye. Thank you very much.
Bye-bye.